regarding the interpretation of administrative acts, we were seeing, no? We will once again read the Canon 36, 35 we completed, isn't it? 36 speaks about the interpretation of administrative acts. An administrative act is to be understood according to the proper meaning of words and the common manner of speaking. So that is the first statement in this canon. Proper meaning of words. We have seen, for example, domicile must be understood as it is explained in Canon 102, 101, 102. No? Proper meaning of words. Domicile has its own technical meaning. Ordinary. Ordinary. The proper meaning of word is in Canon 134. Dispensation. Proper meaning of word as explained in Canon 85. So, administrative acts must be understood according to the proper meaning of words. We already seen with regard to rules of interpretation in Canon 17 also. In Canon 17. Proper meaning. And the common manner of speaking. So, people are not highly educated. So, what people understand, that's what counts. Common manner of speaking. That is the first rule with regard to the interpretation of administrative acts. Sometimes we may have doubt regarding the meaning, regarding the interpretation. At that time, what we are supposed to do? So we have to give strict interpretation. We have to give strict interpretation. What are the strict interpretation? We already seen with regard to laws in Canon 18. Do you remember? Certain laws are subject to strict interpretation. Once again read that canon, one of you Canon 18. Canon 18, strict
laws,
yes,
which prescribe a
penalty
or restrict the free exercise of rights.
Restrict the free exercise of rights. Yes.
Or contain an exception to the law.
Okay. Exception. These three things, three types of laws. Laws which prescribe a penalty or which restrict the free exercise of rights. Free exercise of rights. For example, right to marry is restricted by the impediments I told you. You remember, no?
Yes.
Right to marry. So you cannot increase the impediments. You should not give broad interpretation to the impediments. For example, Canon law says those who are in sacred orders should not marry. If they marry, it is invalid. You cannot say seminarians, if they marry, it is invalid. That is broad interpretation. They are subject to strict interpretation. Who are those in sacred orders? Only clerics, deacons, priests, and bishops. Deacons, priests, and bishops. So that's what. So free exercise of rights. Already first one is penalty. Suspension. You are suspended from celebrating Mass. That means you are not suspended from hearing confession. Only that matter. Minimum of extension. Then whenever there is an exception, normally clerics should not do, but Roman Pontiff can do. That means exception. Only Pope alone can do. So whenever there is an exception, it has to be interpreted strictly. More or less, even with regard to administrative acts, when these three are mentioned, they have to be interpreted strictly. These are about laws. Now Canon 36 speaks about administrative acts that are addressed to the individuals or individual community. Feel free to ask me any question. Administrative act. Now let us look at this Canon 36. In doubt, what are subject to strict interpretation? Canon 36 says, a strict interpretation is to be given to those administrative acts which concern litigation. The first one, the Canon speaks of litigation. Whenever there is a quarrel, some administrative act is given, some obligation is imposed, then it has to be interpreted strictly. Whenever there is a quarrel, the competent superior comes as the adjudicator, mediator, and says, you do this, you don't do this. Because of there is a quarrel. Whenever there is a litigation, it has to be interpreted strictly. First one. Second one, we already know, threaten or inflict penalties. Administrative acts which threaten or inflict penalties. Just as penal laws are to be interpreted strictly, here administrative acts which impose a penalty are also to be interpreted strictly. Then the next one, restricts the rights of persons. We already saw that. Restricts the rights of persons. Canon 18 also refers to it. Only that there it is a question of law. Here it is a singular administrative act. Then one more thing which we have already mentioned. Whenever an administrative act harms acquired rights, then we should be careful always to protect the acquired rights. If administrative act is against the acquired right, interpret it with minimum of extension. We studied already what is acquired right in Canon 4. Remember, acquired rights are as far as possible protected in this code. So when an administrative act comes in the way of injuring or harming an acquired right, that administrative act has to be interpreted strictly. Not acquired right is to be interpreted strictly. Acquired right must be safeguarded. Then, or run counter to a law in favor of private persons. This is what we meant by exception. So, law is one thing. An individual is given an exception. Individual is given an exception. Run counter to a law in favor of private persons. Simple example. So, you are there in the class as 12 of you. One person says, Father, I will come 10 minutes late to the class. The law is all must be here present throughout the class. That person, that too only 10 minutes, that's all. So he asked permission, Father, 10 minutes, so everybody will come 10 minutes late. So when an administrative act is an exception in favor of that private person, the administrative act here in my case is permission or dispensation I have given to him to come 10 minutes late. All should not make use of it and give it broad interpretation. So that is it. In other words, what are the two things that are new in this? Out of the 5, these 2 are the new ones, which are not in Canon 18. Canon, of course, 18 is regarding interpretation of laws. This is interpretation of administrative acts. That's all. Otherwise, these 2 are added in this canon.
Litigation, is it physical?
Litigation, any type of quarrel. Not only physical litigation, but also regarding a property you have litigation. You say it is my property, another person says it is my property. The competent authority says this is what has to be maintained up to now. So it has to be interpreted strictly. Any type of a quarrel, argument, dispute, when an administrative act is issued in those cases, it has to be interpreted strictly. It has to be. The litigation can be between the bishop and the parish priest. Holy See issues an administrative act. It has to be interpreted strictly. So that is canon. So normally, general rule is know the proper meaning of words. Know the proper meaning of words and the common manner of speaking. In doubt, you have to give strict interpretation to 5 of the cases. And what are those? In addition to what is mentioned in Canon 18, whenever there is litigation, whenever acquired rights are harmed, then we have to interpret the administrative act strictly. So feel free to ask me if you don't understand.
But usually the correspondence will be in English or Italian, brother, or Latin?
No. When they write to people in India, they write mostly in English. Sometimes in Latin, but you have to take it to the person who knows Latin. That's all.
Common manner of speaking.
Common manner of speaking is the way in which normally it is understood. One thing is proper, because why the word common manner of speaking is used? Because it is addressed to the individual. The individual must be able to understand it. That's what this canon speaks of. Okay, we go to the next canon. Canon 37. Canon 37.
Well, there is another one.
Yeah.
Canon number 36, para 2.
Yeah, para 2 we omitted, yes. But this already we mentioned the point. But once again we read it. What is contained there I have already explained to you. Administrative acts must not be extended to cases other than those expressly stated. Administrative act is to one person. You cannot extend to another person. Administrative act is concerning one individual matter. So you cannot extend to other matters. With regard to persons and the matter, there cannot be any extension. Last time you got permission. This time, okay, he gave me permission, without permission I go. No. It cannot be extended. Even if it is the same person, it cannot be extended. You are authorized to do something. You are dispensed from something on a particular day. It is valid only for that occasion. Administrative acts should not be extended.
Two people quarrel.
Yeah.
One is given the administrative act.
Yeah, both will be given. The copy will be given to the other. Copy will be given to the other. Sometimes even with regard to the religious, they have problem with the superiors. Then they write to the Holy See. The Holy See sends a copy to the Mother General, copy to the sister. Or Holy See directly writes to the sister, sending a copy to the Mother General. Like that it happens. So whenever there is litigation, both parties must know what the other party has been asked by the authority to do. Understood? Okay. Okay, now we go to the next canon. Administrative acts and the different fora. An administrative act which concerns external forum is to be effected in writing. Likewise, if it requires an executor, the act of execution is to be in writing. The act of execution is to be in writing. Okay, now an administrative act, what we in canon law and even in moral theology speak of internal forum and the external forum. The internal forum is the forum of conscience. Forum of conscience. It can be sacramental or non-sacramental. Non-sacramental. Internal forum. External forum is the forum of public proof. External forum is a forum of public proof. So, an administrative act can be given even in the external forum, of course, non-sacramental, private. With regard to confession, also there can be remission of the penalty of abortion, for example. So it is internal forum. Sometimes, normally it is not given in writing, but forum of public proof, external forum is to be given in writing, because it has to be proved. It has to be proved. External forum has to be given in writing. For example, your appointment as parish priest. The bishop cannot tell you orally you are appointed parish priest, but it has to be given in writing. Only then you can prove it. Always, so many people will say, Bishop told me also. Yesterday he was drunk, so he told me you are the cathedral parish priest. But morning, somebody says, no, I am never cathedral. You are never appointed cathedral parish priest. An administrative act which concerns the external forum is to be in writing. With regard to administrative acts, some administrative acts are given to the person concerned directly without an executor. An executor, without an intermediary. Some administrative acts are given directly to the person concerned, to the beneficiary or to the one under obligation, whatever it may be. Some administrative acts are given directly to the person without any intermediary to execute it, implement it. There are others which are given to the person indirectly through the executor. Through the executor.
Further, will you give one example for that?
Yeah, anything.
Some administrative acts as given directly from the executor.
I mean, I never said that. Why do you say what I did not say?
Some administrative acts as given directly from the executor.
I never said that. You are writing something which I did not say.
Or given directly to the person from the intermediary.
Without any intermediary. I say one thing, you should not write another. Don't put in my words which I never said. I said the government and authority gives. Authority gives. Suppose the doctrine of faith, Congregation for Doctrine of Faith, writes to me directly Sometimes it sends a letter to the bishop and then asks him to execute. The higher authority directly, for example, the superior general directly tells the sister concerned, or she sends a letter to the provincial, call that sister and communicate this. Here the provincial is the executor. Sometimes diocesan bishop is the executor. Vicar general is the executor. That's why we speak of two forms in which administrative acts are given. The first one, without any executor directly, is called the forma graciosa. Forma graciosa. Favorable form. The meaning is favorable form. Favorable form. Because no need of any intermediary. Straight away. There is no intermediary of a priest between God and you. That is forma graciosa. But that is not an administrative act. I am simply giving the example. Higher authority directly contacts the person concerned. Now, this one is called indirectly, it is called forma commissoria. Forma commissoria. Forma commissoria. Through the commissorial form or through an intermediary, it is given. Commissoria. Forma commissoria. This forma commissoria can be again divided into two kinds. The executor can be voluntary executor or necessary executor. What is the meaning? Necessary executor. Forma commissoria necessaria. Forma commissoria libera or voluntaria. Libera, free. Free executor, voluntary means free executor or necessary executor. Necessary executor. I will explain to you the difference. Listen attentively. Suppose a first year philosophy student wants to visit his mother who is sick. So, according to our rule, you have to get permission from Father Rector, unless it is in the city itself. So, he goes to Father Rector and then he tells him, I will consider, and then tells him and sends away. And then Father Rector asks the Vice Rector, he asked me permission, asked him to go for 2 days and come. In this case, the Vice Rector is a necessary executor. He has no freedom. Suppose Father Rector tells him, you decide whether he can go home or not. Here decision making is left to the Vice Rector. In the first one, he is only communicating. Necessary executor, he has no freedom whatsoever regarding the decision. In the second one, it is the Vice Rector who takes the decision. Vice Rector who takes the decision and sends him home. So, the executor, how do we know whether in a particular case an executor is necessary executor or voluntary or free executor? From the wordings of the decree. From the wordings of the letter, we will know whether he is necessary. You are hereby asked to send him home for 2 days. And you are authorized to decide whether he has to go home for 2 days. So from that we know who is the necessary executor and the voluntary executor. Sometimes the Holy See directly, straight away decides the matter. Other times it asks the bishop to be the voluntary executor, depending on the person and the case. Depending on the person and the case. That's it. Very clear. So, administrative acts can be given in 2 forms. Forma graciosa, forma commissoria. Forma commissoria can be forma commissoria necessaria, forma commissoria libera. Forma commissoria libera. So here the canon says, whenever it concerns external forum, it has to be in writing. Secondly, whenever there is commissorial form, it has to be in writing. Whether voluntary or libera doesn't matter. Whenever there is an involvement of an executor, it has to be in writing. It has to be in writing. That's what the canon says in canon 38. 37. An administrative act which concerns the external forum is to be effected in writing. Likewise, if it requires an executor, the act of execution is to be in writing. Even the act of execution, that the superior has the intermediary has fulfilled the function, not the superior. The intermediary has fulfilled the function, has to be in writing. Another common example, for example, Canon 692 speaks about dispensation that is obtained or indulged to leave the congregation. 692. So it is called the indulge to leave the congregation. A perpetually professed religious, he is asking the Holy See to permanently leave the congregation, become a lay person. Normally, the practice of the Holy See is this is sent to the superior general. The superior general only gives the indult to the candidate who is leaving. At that time, the candidate can refuse or accept. Even if Holy See has signed, the sister says, I made a good retreat, now I want to remain here. Means she can remain at the time of execution. So the signature of the candidate or the sister who is leaving is necessary for its coming into effect. Canon 692, last part. 692, second paragraph. Please read that. Is there a second paragraph? One paragraph. Okay, 692. Read that.
Unless it has been rejected by the member in the act of notification,
Yes.
a dispensation from the vows and from all obligations arising from profession.
Yeah. The member has right to reject the dispensation. Some people ask, how can the member, why did she write 3 months ago? So now also recently one sister told me, I was so much disturbed, father, confused, so I wrote. Now I don't want to go. I don't want to go. Suppose I ask you, father, I want 200 rupees. Please bring, because I want to give to the poor. In the meantime, the poor person has gone away. So you went to the room and brought for me. Then, father, I brought you out to accept only. You cannot impose on me. Because I asked a favor. Because I asked you a favor. So I am not obliged to accept. I can reject the favor. If it is my duty to accept, that is different. I asked for a favor, an exception. Many sisters do not know. One general of one rare congregation told the sister, dispensation has come now, so you have to go like that, compelled there, and that sister went and compelled and married also. Then afterwards only her sister came to know that you can reject it. When I was teaching in one group, that sister started weeping. Father, had I known this canon law, my sister would not have given birth to so many children. Not so many children, at least not married. She would have still remained a sister because Mother General compelled her to go. Mother General did not know the law. This sister did not know the law. Those who were around her did not know the law. So a sister was compelled to go. You can dismiss if she has done anything serious following the procedure, but then you cannot force a person to get dispensation. Force a person to get a dispensation. You see in that canon, it can be rejected. So what I am saying, when the Mother General calls this sister, then she has to write, I on such and such a day, I executed the resplay, and the sister concerned as signed. That must be in writing. Actually, they have to send, inform the Holy See that the person has accepted or not.
After signing,
Yeah.
the time is once.
After signing means over. Once means once again we are not obliged. Before signing, you signed the petition, all right. 3 or 6 months it became. After signing, what can? After signing also there is a possibility. There is a possibility according to 690. 690.
The person
Yeah.
who lawfully leaves the institution after completing the novitiate or after profession can be readmitted by the supreme moderator.
Can be readmitted, not must be readmitted. Who decides? General and the council. Yeah.
With the consent of his or her council without the obligation of repeating the novitiate. The same moderator is to determine an appropriate probation prior to temporary profession and the length of time involved before making perpetual profession in accordance with the norms of Canon 653.
Now what will happen? Then the person has to come, though perpetually professed already, once again take temporary profession, and then 3 years you remain minimum, and then make the perpetual profession. But not obliged to accept. Not obliged to accept. Can be admitted if the person is really sincere. That possibility is there according to 690. Some congregations asked me, they want to admit a particular sister who led a more holy life outside the congregation, even though she left. But then they themselves backtracked, saying that all others also want to come, they are also pestering us. Then they did not admit. But there is possibility, even without recourse to the Holy See, to be readmitted.
After some amount of months, duration of time or immediately?
Any time, no duration. The principle is where the lawgiver has not distinguished, you don't distinguish. Lawgiver did not say time. Lawgiver has given time only for minimum of 3 years in temporary profession before making perpetual profession. But in the case of clerics who want to come back, look at Canon 293. One who has lost the clerical state, yeah, no?
If the member is a cleric, the indulge is not granted until he has found the
293, is
A
it?
cleric who has lost the clerical state cannot be enrolled as a cleric again, save by the scripts of the apostolic see.
Yes. Once again, Holy See, you have lost the clerical state. You are dismissed from the clerical state. You got dispensation and married. Wife died. You want to come to active ministry. That you may get, otherwise no. Active pastoral ministry. In such a situation, only with the permission of the Holy See, you can be reinstated. A priest went and married civilly. Returning from the civil after getting, afterwards he got dispensation 4 years. He got dispensation from the Holy See after one year. So, at the first child birth itself, mother and child died. The priest is again converted. Not to marry another woman, but to come back to ministry. Maybe God's punishment. Can he be reinstated? He has lost the clerical state. There is no question of ordaining him again because first ordination is valid. So, with the permission of the Holy See, he can be reinstated. Maybe in a diocese where his identity is not much known, where there will not be scandal. So here, with regard to other religious, non-clerical religious, the power is granted by universal law itself to the superior general and the council. Okay, now we will go to the next point. Please study Canon 37, writing here.
Then, without recourse to the Holy See, we need to write to the Holy See.
With regard to the priest only,
No, religious.
religious, no need of writing to the Holy See. But then when you send the annual report, you have to mention that we have taken that sister, so many things. No need of policy because lawgiver has not given any restriction on the right of the general. That's why I said, that's why I distinguish between clerical, those who have lost the clerical state and those who have ceased to be members of the congregation. So here formally everything you have to ask the Holy See. Now in accordance with the principle of subsidiarity, greater freedom is given to the authorities of the congregation. Authorities of the congregation. Even earlier, for each and every transfer from one congregation to another congregation needed the intervention of the Holy See. Even exclaustration you needed sometimes from the Holy See. But now everything is settled at the level of the congregation itself. Congregation itself. Now the next question, actually not going to the next canon, is the written form for validity. That is the question. Is the written form for validity of the administrative act? In canon law, we always distinguish between validity and licity or lawfulness. Suppose it is not given in writing, is the administrative act invalid? We see in some places it seems to affect the validity of the act itself. Validity of the act itself. For example, the following canons, especially 186. 186 we already studied. Loss of office takes place only when it is notified to the person. Last class we studied, we should not forget. 190, paragraph 3. The transfer is effective only when it is notified in writing. 190, para 3. Note down the numbers. Then 193, paragraph 4. Removal from an ecclesiastical office. (312) para 2. Consent of the diocesan bishop to erect a public association. Consent of the diocesan bishop to erect a public association. Then 638 paragraph 3. 638 paragraph 3. Permission of the competent superior before alienation the province want to sell a property, you need to get the permission of the superior general and the council maybe. So 638 para 3. Then even I would think the permission to erect a new community in a diocese, Canon 609, erection of a new house in a prior written consent of the diocesan bishop. Prior written consent of the diocesan bishop. So sometimes the court seems to say this is for validity. Some other things it does not look it is needed for validity. Validity only for lawfulness. For example, 973, faculty to hear confession. Faculty to hear confession. 973. 1215 para 1. Consent of the bishop to build a church. Then Canon 1361 para 2. Remission of a penalty. Remission of a penalty. Like that, we should not think that every time the written form is required, it affects the validity. Depends. Some cases it may be required for validity. Some cases it may not be required. We have to interpret it accordingly, keeping in mind the general principles regarding the written form. So, written form affecting validity. But we have to always prefer the written form, even if it is only for lawful. We have to prefer always the written form.
Further, it is given that if it is an external forum, it is to be effected in writing.
Yeah.
So it is stressed no further.
It is stressed, but even though you should, for example, you should not celebrate Mass without wisdom. It is stressed only. But some people come with their jati also and celebrate Mass. It is valid only. But it is forbidden. It is forbidden. If somebody does it. This stress, that's why in canon law, yesterday also they were asking me what to do when there is violation of law. They say canon law is old lady without tooth, pallillada kelvi, so you cannot bite. Civil law, if you violate, you can put them in prison. The biggest punishment you can give is excommunicated. People are not bothered also, some of them excommunicated. Only when they are believing, they are worried about excommunicated. Then that's why sometimes it's very difficult to really enforce the law, since violation of law is not sufficiently punished as many people expect. Many people expect. Okay, we will have the break and then